Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Hey, many of you may not realize this, but we may be on the precipice of something really big. Because for those of you who've been geeking out on this channel and all the other channels over the last couple of years, you know that there's been a tremendous amount of litigation that is kind of heading to this one focal point. And the Bruin case was really only the beginning of the chain reaction or the dominoes starting to fall. What we're talking about today are a couple cases that we've been waiting on and bated breath out here on the left coast here, and they are down in San Diego, and I think that we need to understand the significance of what may occur here in the very near future. So today, let's spend a few minutes and talk about, are we entering the final days of magazine and assault weapon bans? Okay, so the issue we're talking about today are two cases that are kicking around in the United States District Court for the Southern District of California, San Diego Division, before the Honorable Roger T. Benitez. Before we get too far down that road, I do want to thank the source of this material, and that is California attorney Costas Moros. I'm going to put his Twitter handle right down there, because if you guys are into Twitter and you're not following him, this guy is doing an amazing job of keeping us up to date, up to the minute update on what's going on around the entire country with Second Amendment stuff. So, Mr. Moros, good on you, and he's the one that actually turned me on to the story. The story comes from KGO, the ABC affiliate in San Francisco. And as you can see here, the story is, California's assault weapons ban could soon be overturned. Here's what that means. And so the panic has begun already in the state of California. Now, why is the ABC affiliate in San Francisco saying that? Well, because it's true. It actually may occur. Here's why. You see, there are two cases, two huge cases, one of which was actually sitting on the doorstep of the United States Supreme Court when the Bruin opinion was issued, and thus punted all the way back down to the Ninth Circuit, who then conveniently punted it all the way back down to Judge Benitez. But there are two cases down there, and you'll understand these are both significant cases. Duncan v. Bonta is a challenge to California's magazine capacity ban, a 10-round capacity similar to what many other states have employed, okay? Miller v. Bonta is a challenge to California's assault weapon ban, similar to what exists in some jurisdictions and very similar to what is being attempted in other jurisdictions, including my own backyard right here. Now, after these cases were kicked all the way back to Judge Benitez, who, by the way, does have a history here with Duncan v. Bonta, and it's been covered in this video and a couple of other ones, he requested both sides to provide briefing as to what sorts of historical analogs actually exist anywhere, anytime in the history of the United States that may justify these sorts of restrictions. Now, of course, that led to us having to do this video right here when the state of California thought that that was an invitation to reopen all the evidence and then supply with some of the most outrageous testimony ever in the history of American jurisprudence, okay? And if you want to check that out, geek out on that video right here. But that, by the way, the state of California's response led to the plaintiffs in this case, which is led by the Second Amendment Foundation, to respond in the following fashion. The state's attempt to ignore the court's instructions and introduce last-minute further expert testimony offered in other cases on the dangerous and unusual weapons question, which has already been settled by this court, is also a naked appeal to the interest balancing and is irrelevant to the question of historical analogs requested by this court and required under Bruin. At this point, defendants are simply padding the record with old and misplaced arguments and extraneous declarations. So now with all the briefs in, we are at the point now where Judge Benitez is going to be issuing his ruling in both of these cases. And therefore, at any moment now, at any day, we could get rulings that will determine the constitutionality of California's 10-round magazine restrictions, as well as their assault weapon ban. Now, this will have an earth-shattering impact within the Ninth Circuit. For those of you who reside in other parts of the country, I cannot guarantee you any impact. Now, inevitably, does this mean that, boom, just like that, we're all living free again like it's the United States of America? Oh, no, no, no. That's not how this is going to work, especially when We have the state of California involved because, as we know, the state of California are pretty sore losers. As a matter of fact, Governor Newsom kind of sees this spanking coming. A few weeks ago, after that horrific mass shooting in Half Moon Bay, Governor Newsom, in one of his tantrums, had the following to say about the upcoming litigation. I look forward to Judge Benitez's decision. It's already written. He's likely to overturn our assault weapons ban. Stay tuned. That's a preview of things to come in the next few weeks. Large capacity magazine clips. That will likely also be thrown out by the same ideologues. Now, in addition to being a really sore loser, what the state of California has proven to be time and time again, Governor Newsom has also proven himself not to be a particularly astute constitutional scholar. He is of the belief that the Second Amendment only would cover the types of firearms that were in existence at the time that the Second Amendment was created, such as muskets. In fact, this is how the governor put it. Presumably, somehow equating those that are doing the same with AR-15s or other assault weapons to those with muskets, I mean, it's perverse. The whole thing is perverse. And of course, Governor Newsom, that would mean that the First Amendment would only cover the type of communications capable in the late 1700s involving a pen, a quill, and some paper. Of course, the right to be free from unreasonable searches and seizures would be only those types of searches and seizures which could take place in the late 1700s, essentially just kicking your door in and rummaging through things. It wouldn't be all the types of electronic surveillance the government can conduct today. Circling back again to the First Amendment, if that line of thought is correct, then the only type of religious freedoms we would have would be if we were members of the churches which were in existence in the late 1700s. Any religion formed in the United States after that, we would not necessarily have freedom to. Using that same analogy, Governor Newsom, the Eighth Amendment would only protect us from the types of cruel and unusual punishments which could be inflicted in the late 1700s, and not all the methods of cruel and unusual punishments which could be inflicted today. But this is the attitude of the state of California, and so when Judge Benitez rules in the plaintiff's favor, which is that day is coming, and that day is coming soon, the state of California is inevitably going to immediately appeal this to a full panel of the Ninth Circuit. Now, this is where things begin to get a little interesting, because we know what the Ninth Circuit wants to do, but with the Bruin opinion being so crystal clear, the question is going to be, what can the Ninth Circuit actually do? It is entirely possible, although highly improbable, that the Ninth Circuit could actually affirm Judge Benitez, and that essentially would end all of this. But that would take at least another year to a year and a half to get to that point. Now, obviously, there could be a certification immediately to the United States Supreme Court, where work is underway to get the Bianchi v. Frosch case out of Maryland, which deals with their assault weapon ban, in front of the United States Supreme Court. One way or the other, there is no escaping that this issue is coming to a final head, and that either the Ninth Circuit is going to get the final say on this under Bruin, or they're going to make the United States Supreme Court do it. So are we in the final days of assault weapon bans and magazine bans? Theoretically, in some ways we are. Are we going to be able to enjoy our freedoms as fast as we'd like to? Highly unlikely, because unfortunately, my friends, the wheels of justice do turn slow. Listen, you may have more questions about this or anything else related to what's left of our Second Amendment rights. I want to thank Costas Moros again for giving us the idea for this story. But in the meantime, listen, if you got any other questions about this or anything else, you guys should know the drill by now. You can always contact us at WashingtonGunLaw.com, or you can call us at 425-765-0487. Now, in the meantime, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here in Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.